Good afternoon, ladies and gentlemen. Can you confirm me, please, that you can hear me clearly?
Yes, thank you.
Excellent. I got some issues with this laptop. It sometimes works, sometimes not. That's why I'm asking.
This is the same with mine, so don't worry.
Is it Lenovo? First of all, I would like to thank you for two things. For the project itself, this is a great and meaningful thing, and I also perceive it as a sort of a counterbalance to the dominant influence of Anglo-American legal culture and style of reasoning, which is omnipresent in our region. And we sometimes tend to forget that there are way closer jurisdictions, they are closer to our style of legal thinking, and that we should pay attention to what they are doing. Well, and I would like to also thank for the possibility to be part of this project. Well, and in the first part of my presentation, I would like to briefly describe the position of the Czech Constitutional Court and highlight some of those aspects of its functioning that are relevant for the manner in which this authority interprets the law, how it argues, and what decisions it makes. Well, and how do I... Here it is. I was clicking on the wrong presentation. So, the very first thing that can be said about the Czech Constitutional Court, it is that it is a typical constitutional court. It performs the function of concentrated constitutional justice, and its task is to secure constitutional balance and serve as a safeguard of democratic functioning of the state and of citizens' constitutional rights. And I would say that court is undoubtedly succeeding in this role. Of course, as a body of the judiciary, it should be technically political. The truth is, however, that it does somehow engage in practical politics. It is activistic from time to time. I would say that it is an institution which is confident, assertive, and often not actually self-restrained in this regard. And when saying this, I refer especially to the way our constitutional court proceeds towards other authorities in the Czech Republic, especially the government and the parliament, and also towards the European Court of Justice. I would like to remind you that it was the Czech Constitutional Court which was the first constitutional court in the European Union to rule against previous decision of the European Court of Justice in famous, or I would say in at least famous in the Czech Republic, decisions of Czechoslovak vengeance. It also ruled against a change of a constitution and declared it void, despite the fact that according to the constitution, it lacks such competence to review constitutional laws. So it is really influential and self-confident court. The Constitutional Court has traditional powers typical for constitutional courts. It plays the role of a negative legislator, ensures the control of international treaties, conducts proceedings in matters concerning elections and the parliament, and has power to rule on constitutional complaints. And there are three types of such complaints: general, municipal, and those based on motions filed by political parties. Constitutional Court stands outside the system of common courts, and does not authorize to supervise the decision-making of other Czech courts or act as another instance. The truth is, however, that the Constitutional Court does not always strictly adhere to this restriction. Our Constitutional Court does not unify our case law. This is up to the two of our Supreme Courts. Furthermore, unlike its predecessor, the Federal Constitutional Court of the Czechoslovak Republic, our new Constitutional Court lacks the power to provide legal interpretation of the law. Nonetheless, the way our Constitutional Court approaches the issue of binding effect of its case law and the way how it interprets the law somewhat relativizes the absence of this power. The decision-making is significantly influenced by its internal structure, and that's a thing I would like to focus at the moment a bit. It deserves our attention. Our court is composed of a total of 15 judges, both professional judges as well as experts outside the judiciary may be appointed as justices, and this in fact affects the court's decisions because the view of a former attorney at law or a law professor are quite specific on occasion, and then might rely on values that a professional judge would neglect. A decision may be rendered by an individual panel or by the plenum, and the court has 4 3-member panels, and this is a thing which is really important about our court, as this creates a rather high number of small panels of justices, which is, according to my opinion, a problem. Justices have various opinions and philosophical attitudes towards the law and politics. That's of course normal. The methods of works of individual panels, they lines of legal argumentation, as well as the way they treat foreign sources, including the case law of the Court of Justice and the European Court of Human Rights. All this differs substantially among the panels, and these differences are also clearly apparent in the wording of individual decisions. And even the legal conclusions of the individual panels can differ in the sense that one can guess, of course, with a certain degree of probability, how a certain panel will decide a certain question. I would say that if the individual panels were composed of a higher number of justices, their decision-making would probably be a little more stable and consistent. The thing is that 2 justices constitute a majority in the panel and have power to change things and set the policy. The drawback of small panels are offset by the fact that the most important types of proceedings are mandatorily conducted in the plenum. I will not deal with that. You will be able to read it in my chapter. It is also possible that a case belonging to a panel may be transferred to a plenum, but justices in practice, the de facto thing is that they are reluctant to do so. So they try to decide the things in a panel if it is possible. In addition to that, a specific role has justice reporter. He or she has a substantial influence over the decision-making of the Constitutional Court in the form, content, and reasoning of its decision. Of course, his task is traditional. It is to prepare a draft of a decision together with the substantiation of the solution which was chosen. And if the reporter's proposal is adopted, he or she will be also asked to draw the decision itself. And the practice is that members of panel quite often follow the opinion and conclusions of justice reporter, and this de facto amounts to an unofficial and informal authorization of one judge to resolve the case, while the other judges accept the chosen solution without further consideration. And another thing is that justice reporter can also exert a substantial influence over the content of a decision based on other, I would say, factual reasons. A time here is a thing which matters. It sometimes happens that other justices do not have enough time to react on the decision which was prepared by justice reporter, as was, for example, in a very recent case of annulment of the Elections Act, which was an extremely important act as the preparation for election have already been in motion. So in this case, the justices received the first version of the decision on January 21st, discussed the proposal 5 days later. The full judgment was pronounced 19 hours after its adoption, and justices were not provided they haven't been provided with its final version. So therefore, they had a very little time to prepare quality objections against the reasoning or express a differing opinion, which of course the outvoted justices didn't forget to mention in their dissenting opinions. And this is not really, I wouldn't say that this is common, but also I wouldn't say that this is something very rare. It happens from time to time, and this is, at least for me, something hardly believable and also, according to my opinion, wrong. Invisible from outside, but nonetheless of considerable influence over the functioning of the constitutional courts can be wielded by assistants to individual justices. 3 assistants support each justice in his or her work, and quite often the assistants are the ones who draft decisions and thus formulate the reasoning in cases where they justice serve as a justice reporter. Assistants' work may not be quite so apparent from the outside. They work for the justice and sometimes even in his or her place, while formally lacking the position of a judge. Of course, ideally, it should be the justice who sets the strategy of the case and determines the decision, and I believe that this is true in most cases. And just these assistants are quite important. It is not unusual that they hold high position in academia. Some of them are associate professors or full professors of law, so the qualifications are often comparable to those of justices. And I believe that the involvement of assistants increases the plurality of opinions in proceedings before the Constitutional Court, which partially relativizes my objection concerning the rather inadequate number of justices in individual panels. And finally, in terms of the institutional prerequisites for decision-making of the Constitutional Court, a significant role plays the Analytical Department. Our court is a part of the Venice Commission, and the Analytical Department makes use of this fact and, where relevant, prepares reports on foreign legislation and case law, and these are then utilized by the judges. Now I would like to deal with the general approach of the Constitutional Court to the interpretation of law. Of course, one thing is the special nature of Constitution and the Charter. Both of them comprise very general provisions rather than specific instruction and solutions. Therefore, the style of interpretation is different than the one which is typical for common courts. Also, I'd like to emphasize that Constitutional Court as an authority is not subject to any external control. Well, it can be limited to a certain case by the case law of the 2 European courts, but it is not subordinate to any of these courts in terms of being lower instance, which gives it more freedom. And this allows our Constitutional Court to take into consideration more values, people's stories, political arguments, and further aspects that are usually out of the reach for ordinary courts. The latter are usually bound primarily by hard law, and their room for discretion is limited. And finally, during the first decade of its existence, the Constitutional Court had to deal with the fact that part of the Czech law, probably as in your countries, had been adopted basically unchanged from the previous totalitarian era, but nevertheless had to function in an environment based on different values. And as a result of this, the Constitutional Court shows a reserved attitude towards the grammatical method of interpretation. It perceives its words only as the initial examination of the legal norm. It is only the starting point. And what is more relevant is to explain and clarify the sense and purpose of the norm, to provide the logical and systematic interpretation, etc. The court has not specified any order in which all these methods should be used, and the truth is that in practice these methods work in a sort of a continuum. They are often used all together as one complex rather than individual subsequent steps of a process called by academics interpretation. And what is apparent, however, is a great significance carried by the logical interpretation. As regards grammatical interpretation, there are several cases where our Constitutional Court has not hesitated to rule even contra verba legis in the specific cases. And along with the teleological interpretation, a considerable weight is attributed to comparative interpretation of constitutional law. Well, and now the reality. I feel a duty to mention that the choice of judgment was not completely representative. It does not provide a comprehensive view of the work carried out by our Constitutional Court. There are several reasons behind this. The reasons are closely related to the conditions set by the research design and also to the characteristics of the Constitutional Court's work and that of the individual justices. And that is also why I paid so much of the valuable time to the description of the functioning of our Constitutional Court. All these facts predetermined which decisions would be chosen for the assessment. And this can be demonstrated on justice rapporteurs and the frequency of their appearance in the set of the chosen 30 decisions. The conditions of the project were favorable for those justices who are open to external sources of law. Thus, for example, Justice Kateřina Šimáčková is one of the most mentioned justices in my set of decisions. So, the truth is that willingness of individual justices to openly work with external decisions varies considerably. However, the fact that the decisions of both European courts are not cited does not necessarily have to mean that the other justices would perhaps completely overlook case law of these two courts. I don't want to say that. The fact is that we are unable to determine ex post from the reasoning of the decisions whether or not the case law of these two courts was considered. In other words, the influence of the Constitutional Court of these two courts on Constitutional Court could be greater that might appear from the chosen 30 decisions, which I don't know. As a matter of fact, I believe that such an approach could be a part of a strategy followed by our Constitutional Court, since silence is especially practical in cases where the conclusion made by the Court of Justice or European Court of Human Rights are not found satisfactory. So rather than acknowledging a conflict, it seems more appropriate to avoid it by not admitting its existence openly. Well, I will first try to evaluate the constitutional reasoning from the qualitative point of view, and I will start with methods of interpretation, and let's start with the grammatical method of interpretation. And this method is basically only a marginal method in the area of fundamental human rights and freedoms. Well, it was so at least in my group of 30 cases. While the Constitutional Court itself calls it euphemistically as a starting method, this translates in practice into free discretion as to the contents of the relevant right of freedom. So the meaning of the words used by the Charter and by our Constitution is does not examine it in any way. The substance is probably taken into the consideration at some elementary level, but this is not explicitly admitted in individual decisions, and the whole process often probably takes place subconsciously. It can be stated with slight exaggeration that grammatical interpretation is not considered sexy enough in the Czech Republic. The general approach to fundamental rights regulated by the Charter is simply that the Constitutional Courts plainly note the existence of such a right and the possibility of its impairment in the case. And the contents of the rights are then clarified using other methods of interpretation. Also, logical arguments have certain auxiliary significance in the interpretation of the law by the Constitutional Court, but they do not belong among arguments commonly used by our Constitutional Court. The use of domestic systemic arguments is usually in cases where the Constitutional Court infers a certain conclusion on the basis of combination of several provisions of the Constitution and of the Charter. This is typical, for example, for our Article 1 of our Constitution, according to which the Czech Republic is to observe its international commitments. And this provision is often used in combination with other provisions, especially of the Charter. And this is how interpretation is found that conforms either to international a treaty or a decision of an international court. However, this is not a matter of direct determination of the content of one provision on the basis of another. The logic here is that the second provision, the Article 1, opens the door for reflecting an external source, typically the European Convention, which then in turn influences the interpretation of first provision. So I didn't notice in any case in my set of decisions where a fundamental right would be interpreted purely in view of its position in the structure of the Charter. When it comes to interpretation on the basis of subconstitutional law, well, things are quite complicated here as well. The Constitutional Court is not bound by the subconstitutional law, so sometimes it uses it as an argument in favor of a certain decision. And I found also one decision in my group of 30 where our Constitutional Court simply ruled against the wording of the act in question, despite the fact that the Charter contained a provision pointing on subconstitutional law. So it was it had a duty to take it into the account and not to rule against it. So, and I believe that this is related to the fact that our Constitutional Court is primarily a value and policy-oriented body rather than a classic tribunal. So it usually prefers what is hidden in the Constitution and in the Charter over our subconstitutional law. When it comes to interpretation on the basis of case law of the Constitutional Court, this is a very common method of interpretation, and I would say that it represents a basic modus operandi of our Constitutional Court. Basically, all the rulings of the Constitutional Court comprise references to its previous case law. I myself call it as a snowball effect, which is apparent in the Constitutional Court's decision making. The conclusion of its previous decisions are repeated in new decisions, which are added to the original ones, and then later they are quoted together, which ultimately creates the impression of a clearly and convincingly established law. And from this point of view, I would say that our Constitutional Court strongly resembles the European Court of Justice. This court is doing the same thing. It repeats its former decisions and the conclusions without any closer analysis of these decisions and without any closer connections to the facts of the previous cases. So, in substance, our Constitutional Court merely constantly repeats its general conclusions until it eventually creates the impression of a precedent. Interpretation on the basis of the case law of common courts, well, this method has only a supportive role, and it is not very common. I found no decision in the set of my 30 decisions in which the court would interpret fundamental rights on the basis of normative acts of other domestic states' organs. However, these institutions can interfere into proceedings as amicus curiae, and they often do so. So I would say that somewhere they may have influence, but we just don't see it in the reasoning of the judgment. When it comes to external, systemic, and comparative law arguments, these are really the important ones in the reasoning of the court. What is noteworthy is that is the way the Constitutional Court works with the text of international treaties. In general, and specifically with the wording of the European Convention. Only in a single decision in the set of my cases was its international origin taken into consideration. The concept of autonomous interpretation was emphasized. In all other decisions, the Czech Charter and the rights it protects were interpreted in the context of the European Convention and other international treaties. And I myself call it as a principle that I use the term principle of homogeneity, which became, according to my opinion, a part of our Czech constitutional law as a result of constitutional court decisions. Our constitutional court interprets the same rights protected by the Charter and the Convention in the same way. At the same time, if there is a difference in the wording of the right, this difference tends to be neglected, and the right is still interpreted homogeneously according to the European Convention. The court has never designated this approach as such, but you can clearly see it. It was present in all 30 decisions and scrutiny. When it comes to interpretation based on decisions or case law of international fora, I found just one decision where an external international court was taken into the account. It was a decision of International Court of Justice regarding the jurisdictional immunity. And I would say that it might be said somewhat poetically that no stars can be seen when the sun is shining. And in the case of the Czech Constitutional Court, the sun is the European Court of Human Rights. When it comes to this court and the use of its decisions, this is something really dominant. Our constitutional works regularly with decisions of the European Court of Human Rights. And we can distinguish three approaches. The first is that our court refers to European Court of Human Rights case law in support of its arguments, and then uses phrases like the Constitutional Court in conformity with, the Constitutional Court agrees with the European Court of Human Rights and its decision. The second, our Constitutional Court adopted a parallel approach, where it both interprets the Charter and also repeats the conclusions following from the case law of the European Court of Human Rights. And the third approach could be described as borrowing or substitution. It is characteristics by citing the case law of the European Court of Human Rights without simultaneously considering the Czech law, which is thus assumed to be the same. Personally, I would liken the court's approach to the Charter and Convention as interpreted by the European Court of Human Rights to the DNA double helix. The DNA carries genetic information, and it consists of two mutually intertwined strands. And similarly, our Constitutional Court defines the contents of fundamental rights based on the Charter and on the Convention, and which both carry a piece of information as to the desired standard of protection in the Czech Republic.
Professor Sehnálek, may I ask you to finish approximately in 2 minutes, please?
I will. Bad timing. I'm sorry for that.
This is the most important part, I know. Just the key to time limits. Thank you.
So, to put it briefly, very little attention is paid to the facts of the cases, which were dealt by the European Court of Human Rights, which is quite interesting, since I had two cases where the same decision of a European Court of Human Rights was used by different panels, by panel and by plenum, and on this same decision of the European Court of Human Rights, they reached completely different opposing conclusions, completely different completely different conclusion. Well, comparative law arguments, they are used quite often. However, I would like to emphasize that comparative arguments as used by the Constitutional Court have nothing to do with the comparison as a scientific method. It usually works like that, you know, hey, look, in Austria and in Germany, there is this regulation, it's similar to our regulation, therefore the conclusion must be following. So these arguments are quite often, but they only play a supportive role. Theological interpretation, quite surprisingly, wasn't used at all in the set of my 30 decisions, but I believe that that was caused by the fact that our court relied heavily on decisions of European Court of Human Rights and on its own case law. So it wasn't necessary to use this method of interpretation. When it comes to subjective theological interpretation, zero occurrences. And arguments based on jurisprudence, and that's the last thing I would like to mention. That's another quite interesting thing. These are quite frequent. They appear regularly. They play a supportive role in decision-making of our Constitutional Court. And there are several interesting things about our Constitutional Court. First, it does not utilize foreign scientific literature. For example, in case of charter, European Convention, one could use German or Austrian commentaries. They were not used at all. And another, and I would say funny and also problematic thing is that judges often tend to cite the works they authored or co-authored. So they are using their own conclusions which were published in support of the conclusions which are present in the decisions they render. And in one case of my 30 decisions, even the judge was referring to its own work, which hasn't been published yet, which is, I believe, ridiculous. Well, let me come to conclusion, since I'm running out of time. I would say that our Constitutional Court relies heavily on a comparative method of interpretation. It works regularly with decisions of the European Court of with the European Court of Human Rights. However, the approach is different. The Czech Constitutional Court is not very self-restrained. It doesn't work with facts of the case. It doesn't reflect the subsidiary role of the European Court of Justice and its case law. It doesn't reflect the fact that the cases do not have effect erga omnes. Well, and that's probably all. For details, please read my chapter. Thank you.